of this development. Joining us is Prashant Bhushan, senior lawyer at the Supreme Court. Mr. Bhushan, many thanks for joining us. Let's just take this as an instance now, because in the case of R.V.Raveendran, he did, when the hearing of this case actually started, disclose the fact that he held shares in both RIL as well as in RNRL. This disclosure has come as a surprise. We don't know the nature of the association that his daughter has, what the company says, and that's Reliance's statement that AZB has at time to time consulted with Reliance Industries on global matters. Should Raveendran have recused himself in this matter?
Yes, I think he should have. I think he should have recused himself at the very first instance when he discovered that he had shares in Reliance, which he did right at the beginning of this case. You see, this principle which the court has adopted in its Code of Conduct in 1997, that if a judge has shares in a company, he needs to only disclose them, and thereafter if the lawyers do not object, he can continue hearing that case, in my view is not a correct principle and needs to be modified. This is because most often lawyers are very reluctant to object to judges hearing a case because they are appearing before that judge day in and day out, and they feel that saying that a judge should not hear the case amounts to an expression of no confidence, and no lawyer wants to say that to a judge. So therefore this principle needs to be modified, and the principle laid out in the Bangalore Declaration in 2002, which says that if any judge has any financial interest in a case or in a company whose case he is dealing with, he should recuse himself. That's the correct principle which needs to be adopted.
Right, but Mr. Bhushan, let's just talk in terms of practicality, because you are talking about clause 2.5 of the Bangalore principles, and let me just read that out for the benefit of our viewers. You say a judge shall disqualify himself from participating in any proceedings in which the judge or a member of the judge's family has an economic interest in the outcome of the matter of controversy. We've got about 22 Supreme Court judges at this point in time, sir. We've already seen, as far as this case is concerned, 6 working days have been lost. These are people who have disclosed, and if you look at what has been disclosed, just day before yesterday, practically every judge has some security to his name at this point in time, some share of some company. Isn't this going to add to the logjam that we currently already see in our courts?
No, I don't think so. What needs to be done is that the judges should disclose all their possible conflicts of interest as far as possible. That is, their shareholdings, their sons and daughters, affiliations with various companies, etc., to the registry right in advance and from time to time, so that the registry can avoid listing cases of those companies or those entities before them. See, in this case, if this kind of a practice had been followed, then perhaps this problem would not have arisen. Then Justice Raveendran would probably have known right at the beginning that his daughter was in a firm which is advising Reliance in these matters.
Mr. Bhushan, do you expect instances of judges withdrawing and recusing themselves from high-profile corporate cases of this nature increasing now with these voluntary disclosure of assets coming into place? Do you think that's going to increase even more now?
Yes, I think so, because so far the judges by and large had not been treating this as an issue. That is, the fact that they have shareholdings in certain companies, and many of them were routinely dealing with the cases of those companies without even disclosing their shareholding, because they did not think that this was a major issue. And that's a legitimate, that's a possible point of view. Though I do not agree with that point of view, I feel that in accordance with the principle that judge must be totally impartial and that he must not even appear to have any interest or any particular partisan interest in that case, judges should automatically recuse themselves. And I don't think that any principle of necessity applies here, because there are a large number of judges who do not hold any shares. There are also a much larger number of judges who don't hold shares in particular companies.
Right.
So
but just to take that point forward,
no problem.
just to take that point forward, Mr. Bhushan, because, you know, as you yourself said that there are some judges who don't hold any shares in a particular company, but, you know, these are judges who are going to have to deal with disinvestment-related issues, arbitration proceedings, winding up proceedings. You know, at some point, if they are invested in the markets, they may have a conflict of interest. So would it then be a fair question to raise at this point in time for people like us who deal with the television medium, the 24-hour business news medium? We cannot invest directly in the stock markets, only through mutual funds. Should something like that then be made mandatory as far as the judiciary is concerned as well?
Yes, that's something which can be considered, which should be considered, whether judges should at all be dealing in shares. And that's something which needs to be seriously debated. In fact, this entire code of conduct which was adopted in 1997 was a code of conduct adopted by the judges in a Chief Justice's conference. There was no sort of public disclosure of this code of conduct, no discussion before it was adopted. These are matters which should always be disclosed, discussed by all the stakeholders, including members of civil society, including litigants, lawyers, etc. And then only these principles should be finalized. It's not an insurmountable problem. It's a problem which can easily be surmounted, and it should be.
Prashant Bhushan, many thanks for joining us with that perspective. Well, that's the story as far as the Judge Raveendran recusing himself in the high-profile AMBANI gas tussle case. But coming up next on this show, the government made